Good afternoon and welcome to Greenfields Solicitors YouTube video with myself, Raheela Hussain, the Principal Solicitor of Greenfields Solicitors. During this show, I will be today answering lots of popular questions that we have from members of our audience and from people who eventually become clients at Greenfields Solicitors, which I hope you will find helpful, informative and interesting. Just to confirm that all the information I provide on this show is just that, information. It should not be relied upon as legal advice. If you do require legal advice, then please do call Greenfields Solicitors on 0208 884 1166 and please book a consultation to speak to either myself or any of our team members at Greenfields Solicitors who would be pleased to assist you in your immigration matter. Now, Greenfields Solicitors are specialists in all aspects of UK immigration law, human rights law and nationality law. That is in fact the only area of law we practice at Greenfields Solicitors, so we are real specialists and experts and can very much help anybody who requires help in their immigration matter. Now, let's go through some popular questions that I received that perhaps our audience will find really interesting. So I'm going to read a question that I received from one of our audience members. So the person said, I am a Zimbabwean national and I have been an overstayer in the UK for the past 5 years. I have made an application to the Home Office requesting leave to remain in the UK as I have made a life in the UK and I cannot go back to Zimbabwe as I am the breadwinner of my family there. But the Home Office have refused my case. I also have a British partner and a young child and really need to stay in the UK with them. The Home Office did not give me a right of appeal when they refused my case. What can I do? Well, if the Home Office have not given you a right of appeal and have refused a human rights claim, you may have a couple of options available to you. For example, it may be possible to make a judicial review application at the High Court in order to request that a High Court judge listen to your claim, and you may request a remedy such as asking the Home Office to either reassess your claim and granting you leave to remain, or perhaps asking that the High Court judge order the Home Office to grant you an in-country right of appeal, so that way you could argue your case before an immigration tribunal. Also, it's really important to look at the notice of immigration decision the Home Office served upon you, because it may state on there that they have given you an opportunity to submit further grounds, or what we call a statement of additional grounds, under section 120 of the Nationality, Immigration, Asylum Act 2002. Sometimes the Home Office give applicants the right to submit a statement of additional grounds where they allow a person a further opportunity to provide further information to the Home Office that may, in the end, allow the Home Office to exercise discretion or to allow them to reassess the claim with the aim of granting that individual leave to remain. Now, if you're unsure of what option you should take, or if you need affirmative legal advice, then I would suggest to you, please obtain strong legal advice in order to advise you of the best option available in your case. Now, going on to a slightly different topic, as I mentioned, section 120 notice that is sometimes provided by the Home Office. This allows individuals, as I've highlighted, to give further information to the Home Office to request that their case be reassessed based on new information or new documentation, and also to update the Home Office of any new circumstances they had. Statements of additional grounds under section 120 often occur where an individual has previously been refused a visa application, time has passed and they wish to make a further application to the Home Office, or where the Home Office write to them and grant them this entitlement. The good thing about statements of additional grounds is that no Home Office fee is payable, currently anyway. So the individual can draft grounds, put documents forward and submit it to the relevant Home Office team for their consideration without having to pay any Home Office fee. There is no time limit on how long it takes a statement of additional grounds to be assessed by the Home Office. It can be a matter of weeks up to a matter of months, or with some of our clients they've been waiting considerably longer. The important point is often the applicant may remain in the UK whilst their case is being progressed by the Home Office. Now, I'd like to talk about a second question that was asked, and it went along the lines of something like this. Miss Hussain, I'm on a Tier 4 general visa and I'm about to marry a British lady in the UK. However, she earns only £15,000 per year, which I have read is below the £18,600 threshold in the terms of financial immigration requirement. I'm concerned that she will not be able to sponsor my spouse visa application if I marry her. I'm wondering, is there any way I can remain here? Is there any possibility of me making an application to remain in the UK, even though my partner does not earn the required income? In such circumstances, it is quite difficult to obtain leave to remain in the UK, where in this case, the gentleman's wife is not earning the relevant £18,600 per annum. However, it is possible still to submit an application to the Home Office asking them that the gentleman be granted leave to remain if there are good enough grounds. So for example, we would need to assess why the lady cannot perhaps get a part-time job to earn the additional £3,600 requirement. If she has some medical problems or childcare issues or anything else that makes it difficult for her to earn the £18,600, then we can obviously present this to the Home Office and ask that they exercise their discretion and grant the gentleman leave to remain outside of the immigration rules. In addition, if there are any children of the family or perhaps the lady's pregnant, then we can look into making grounds to the Home Office in our application for him, which would also seek to argue the best interests of the child. Also, we must remember that if there is a family member here, then the gentleman has clearly established a private life in the UK and potentially also now a family life in the UK. So he can also rely on a human rights argument. In this case, it would be something along the lines of Article 8 of the Human Rights Act, which is he has the right for private and family life, and he can make an application to the Home Office requesting leave to remain based on his human rights as well. Again, we would suggest that if you're unsure, please do get legal advice. So now we have another question, and on this occasion, my parents are from India and I hold indefinite leave to remain in the UK. I earn £25,000 per annum and I work in the IT industry. I would like to sponsor my parents to come to the UK. My father is very ill and he suffers from chronic illnesses, so I would like to care for both of my parents once they come to the UK. What are the requirements for my parents to come to the UK? How can I bring them here? Well, it should be noted that since 2012, the Home Office did change the criteria in how to bring adult dependent relatives who are 65 years and over, and it really no longer depends on financial dependency, which was what the criteria was pre-2012. Now, the Home Office states that non-EEA adult dependent relatives will only be able to settle in the UK if they can demonstrate that as a result of either age, illness, or disability, they require a level of long-term personal care that can only be provided in the UK by their relative here and without recourse to public funds. So what does this mean? Well, it means that the applicant, who the gentleman's parents or the father, must, as a result of his age, illness or disability, require long-term personal care in tasks such as washing, dressing, cooking. It must also be proved that the son in the UK can, even if he sends money to his parents for his father's care in India, that it is not possible for the father to obtain the required level of care in the country where they are living in India, because either that level of care that the father requires is either not available there, or there is no person in that country who can reasonably provide it, or because perhaps it's not affordable there. So perhaps his parents do not have any other relatives there, perhaps they have no other children there, perhaps they're all by themselves there. So we really need to find out more information about this gentleman and his parents' circumstances. An entry clearance officer really needs to be satisfied that the parents, if granted leave to enter in the UK, would be maintained and accommodated without recourse to public funds. So there is a lengthy and quite complicated criteria in trying to bring adult dependent relatives to the UK. It's not something straightforward. A lot of documentation and obviously medical evidence will need to be provided to assist a case and support the claim made by the overseas persons. Also, I should probably point out that the British High Commission and British Embassy have their own medical doctors that they can actually use to assess whether an individual has that level of illness or disability that they claim. So it's something to be aware of. So we have another question here. I am a teacher in the UK and I'm currently in the UK on a spouse visa which will expire in August 2017. I'm married to a British citizen and have no children, but our marriage is sadly in difficulty and my husband has threatened to file divorce proceedings. I do not want to go back to Canada as I have a good job and I'm well settled in the UK. I love the UK. My parents have sadly passed away and my only other sibling is my brother who lives in Mexico with his wife. Can I remain in the UK even if my husband divorces me? Well, this is an interesting situation as the Canadian lady who is a teacher here is in the potential of being divorced and she's stating that she has no family to return to in her home country of Canada. She mentions that her parents have passed away and her only other sibling is living in a different country with his wife. So she's clearly concerned about going back to a country where she has no ties, no family and potentially no assets, and where she feels very well settled, safe and happy in the UK and wishes to remain here. So what do we do in these circumstances? Well, again, we need a lot more information from the lady. She'll probably need to have a consultation with us at Greenfields Solicitors so we can get a lot more information on her background. And we could potentially look into an immigration rule, which I will read to you, states where an applicant is aged 18 years or above and has lived continuously in the UK for less than 20 years, but there would be very significant obstacles to the applicant's integration into the country to which he or she would have to go to if returned to leave the UK. So I'm just going to repeat some important words in that immigration rule. So the lady would potentially face very significant obstacles to integrate back into Canada if she had to leave the UK. Now, as experienced solicitors, we could, if she so wished, look into making an application for her to the Home Office, requesting that she be granted something called discretionary leave to remain, which would be a variation of her current visa before her spouse visa expires. Effectively submit an application to the Home Office and request that she be granted discretionary leave to remain because there is a relevant immigration rules that she may well fit into. We could also argue her human rights under Article 8 in that she has clearly established a private life in the UK and she feels well settled, she's well educated, has a good job, has friends, has family here, is somebody contributing to the UK economy and maybe a person of good character. So we would, in such circumstances, implore the Secretary of State to grant her discretionary leave to remain. Now, if she or anybody generally under human rights claims under Article 8, they're often granted 2.5 years discretionary leave to remain when their cases are successful. Now they can live, they can work, they can travel, they're part of British society. They would renew this every 2.5 years, this particular type of visa. And after 10 years under the current immigration rules, they can apply for indefinite leave to remain. And effectively after that, apply for naturalisation as a British citizen. So I hope I've given our audience an overview of the kind of questions and the kind of queries we receive on a day-to-day basis at Greenfields Solicitors. We very much hope that if you have an immigration problem or require immigration help or assistance, that you approach Greenfields Solicitors. We do provide telephone consultations if you are unable to attend our offices in North London for advice. So you can ask for myself or any of my team members. I am a solicitor with approaching 14 years immigration experience, predominantly in immigration, as I qualified as a solicitor in July 2003. So if you have any questions, any queries, and you would like to have a consultation with Greenfields Solicitors for good, accurate legal advice, please do call on 0208 884 1166. You can also email us at info@greenfieldsolicitors.com, and our website is www.greenfieldsolicitors.com. I thank you for watching this video with myself and hope you found it both educating and interesting, and very much look forward to seeing you again in the near future. Thank you and take good care.